Good morning. Welcome to day 9 of our hearing. As tomorrow is only already the final day, the tribunal discussed yesterday evening about the post-hearing steps, and we would kindly invite the parties to consult with each other and inform us tomorrow after the in our closing statements whether they have any joint ideas on the following aspects. First one, the finalization of the transcript. Second, the timing, number, sequence, content, possible page limits for the post-hearing briefs. And then as a next item, the cost submissions also here, number, sequence, timing, and content. So if the parties can inform us tomorrow about their ideas, this would be appreciated, and we will then move it from there. Are there any other housekeeping matters the parties wish to address?
Good morning, members of the tribunal. We will have those conferrals regarding the next procedural steps. Regarding today, you will remember that you instructed the parties to reach an agreement on how to ensure that we finish the day timely. We agreed that each party would have 3 hours today, which is less than the remaining allocated time, which I don't have the number in front of me. I think it was in excess of. It was about over 5 hours. So we reduced the time. We think that it's workable, even if we were to finish at 5:30. We would propose, if the tribunal were agreeable to that, to reduce the lunch break to 30 minutes, and also make the coffee breaks shorter. With our apologies, but we are in your hands, obviously. The position that we as claimant have is there should be enough room to finish at 5:30. But if for whatever reason we could not finish our 3 hours, we don't want sort of to be told at 5:30 that we have to stop the cross-examination because it's 5:30. It's probably would, under those circumstances, only last like 5 or 10 minutes longer. I think each body should have those 3 hours that are allocated. That's our position.
Does the respondent wish to comment, or can we just take note?
Just to confirm that I believe I'm on, that the parties have discussed this. I think the 3 hours for each side is ambitious but doable if we are all conscientious and try to make sure that we move the calendar along, including with the shorter breaks that Counsel for Claimant has identified. Obviously, we'll operate in a rule of reason. We may reassess at the lunch break if need be. We're just trying to ensure that the parties are not, and the tribunal are not eating into their own preparation times for the closing by running late tonight. So again, we think it's doable with conscientious effort on all sides.
This is noted, and we will then reduce the lunch to 30 minutes and the coffee breaks to 10 minutes each, and we will also try to be efficient with our questions, and now maybe we even start questioning the Peruvian tax experts with a couple of questions, and so okay, let's move it from there. Okay, I think then we can call in the experts for claimant.
He will be in momentarily. Thank you, Madam President. And Madam President, just before the expert begins, I want to note briefly that he will discuss at some point protected information, just so that Marissa can take that into account for purposes of the video recording.
Good morning, Mr. Hernandez. Can you hear us well? Welcome to this hearing. I briefly introduce ourselves. My name is Inka Hanefeld. I'm the presiding arbitrator in this case. I'm sitting here with my co-arbitrators, Professor Tawil and Dr. Cremades. You have been called by claimant as the Peruvian tax law expert, and I kindly request you to read out the declaration that should be in front of you.
Expert declaration. I solemnly declare by my own conscience that my statement will be in accordance with my sincere belief.
Thank you. Do you have your expert reports CER 3, 8, and 13 in front of you?
I do have 3. But I do not see the number of the document. I have these 3 here. I don't see the number of the reports. These are my expert reports for the rejoinder and then the other.
So these are your 3 reports, and you can confirm that these are yours.
Perdón.
So you have your 3 reports in.
Sí, los estoy.
Yes, I'm looking at them.
Sí, efectivamente.
Yes, indeed. These are my reports.
Perfect. And I understand that you will now give us a presentation, and afterwards you will receive questions from the parties and the tribunal. So please start with your presentation.
Good morning, members of the tribunal. It is a pleasure to be here before you. My name is Luis Hernandez Berenguel, and I have been called by Freeport as an expert on tax law. That's my specialty. I am a lawyer. I have over 52 years of experience in tax and corporate matters. 30 years ago, I founded the law firm called Hernandez y Compañía, where I currently work still. I have been a professor of tax law at the Pontificia Universidad Católica del Perú, the oldest university that is private in Peru, and I've done that for 46 years. During my career, I have provided advice to hundreds of companies on tax matters. I've also participated in the drafting of large projects or drafts. I have been the person in charge primarily of preparing the single unified text of 1982. I also was part of the committee in charge of preparing regulatory rules for the mining law in 1993. In my presentation, I'm going to touch upon 5 topics specifically. First, Cervera incurred losses only when each assessment became final and enforceable. Cerro Verde suffered a separate loss with each final and enforceable assessment. 3, failure to waive penalties and interest is not a taxation measure under Peruvian law. 4, the government should have waived penalties and interest charges against Cerro Verde because there was a reasonable doubt. 5, so not applied the stability guarantees to the whole of the UEA A's of Yanacocha. I'm going to talk about the first topic. Cerro Verde suffered damage only when each assessment became final and enforceable. The assessment is only enforceable when it becomes final. An assessment is also known as a resolución de determinación or multa, is only enforceable, that is to say, is only coercively collectible when it becomes final. In Peruvian law, an assessment becomes final when it is not challenged by the taxpayer or, if challenged, the SUNAT, or the tax tribunal, dismisses the challenge. It becomes final when it was challenged and appealed and the tax court decides against the taxpayer. The assessment is not enforceable until it becomes final. This is so to ensure that the government does not coercively collect the assessed amount while the taxpayer challenges its legality. This is a fundamental right in the Peruvian system. Only when an assessment becomes final, the amount assessed becomes an enforceable debt, and the taxpayer obligation arises. Before this final assessment, there is no payment obligation. The debtor does not have to pay anything, and the creditor cannot enforce payment. Only when the assessment becomes final, the amount assessed by SUNAT becomes enforceable, and the payment obligation by the taxpayer arises. When the debt becomes due, SUNAT may coercively collect on the debt, that is to say, enforce the assessment, if the taxpayer refuses to pay it. Article 115 of the Tax Code is the key provision on this matter. The article establishes when the assessment becomes enforceable. That is the difference between the Peruvian system and other systems. In the Peruvian system, the assessment becomes enforceable only when we are dealing with the provisions of Article 115 of the Tax Code. It says, this Article 115, it says that only the enforceable debt is enforceable when it is established in a final assessment. Here we see the provisions of 115 of the Tax Code, and it says that the enforceable debt is the one established by a resolution of an assessment of penalty that is not complained against by the legal deadline. And it is established under a resolution that is not appealed during the deadline established by law or established by a resolution of the tax tribunal. Peru's position is incorrect. I'm sorry, I think I skipped one. Cerro Verde incurred losses only when each assessment became final and enforceable. Then, and only then, did the assessed amount become enforceable because it was determined with certainty. The payment obligation arose, and SUNAT could have enforced the assessment if Cerro Verde refused to pay. Cerro Verde could not have incurred any losses before the assessment became final because the assessed debt was not enforceable, and therefore there was no obligation to pay. The position of Peru is incorrect. Cerro Verde, as we saw, could not have incurred losses when SUNAT notified each assessment because, as we saw, the assessment was not yet final, and consequently, the amount of the assessment was not enforceable. Cerro Verde had no obligation to pay, and SUNAT could not coercively collect on the assessed amount. The arguments by Peru do not support Peru's position. Peru alleges that the prepayments and the accrual of interest support its position, but Peru is wrong. Prepaying an assessment is simply a taxpayer right. It's not an obligation. Also, the obligation hadn't yet arisen. Interest accrues from the deadline for filing taxes and royalties and not from the notification of the assessment, as Peru's experts say. You can see here there's a timeline, and according to Peru's position, interest began accruing from the notice of the assessment. This has no support in any legal provision whatsoever. At any rate, if it were consistent, Peru's position should have been that interest begins accruing from the tax and royalty filing that should have been filed. The second issue is that Cerro Verde suffered a separate loss with each final and enforceable assessment. Each assessment is a unique and separate administrative act, SUNAT conducted separate audits for each fiscal period, and as a result of these audits, issued separate assessments for royalties, type of tax, and penalties for each tax period. Each assessment was based on different accounting records, different purchases, sales of assets, depreciation, and sales of mineral, and each assessment resulted in different amounts. Cerro Verde had to challenge each assessment independently before SUNAT and the tax tribunal. None of SUNAT's assessments or the tax tribunal's decisions had binding effects on subsequent assessments, the ones that came after. SUNAT and the tax tribunal had to decide on each of Cerro Verde's challenges independently, without being bound by their prior decisions. One could say, okay, the taxpayer is right in assessment 1, but in assessment 2, on the basis of the same tax or royalty for a different period, then the decision could have been different. SUNAT and the tax tribunal never indicated that they were bound to adopt the criterion of the first assessments in resolving Cerro Verde's challenges to the subsequent assessments. After the 2006 and 2007 royalty assessments, SUNAT applied stability guarantees to the entire EAUs. SUNAT issued a report in 2012, 084 of 2012, in which it clearly stated, without any doubt whatsoever, and it's expressly said so, that the stability guarantees applied to concessions and EAUs. It did not say that it applied only to investment projects approved or included in the stability agreement. It expressly indicated that these stability agreements applied to concessions and EAUs. SUNAT and the tax tribunals issued resolutions in other cases, Milpo, Yanacocha, and Tintaya, in which they clearly applied stability guarantees to the entire concession and EAUs, unlike what SUNAT did with Cerro Verde. Let us look at an example, a practical example. A person signs a loan agreement with the bank without an acceleration clause, and the person has to pay the amount loaned in installments and under different deadlines. The fact that there is a breach and there is non-payment of one installment and the creditor can enforce payment, that does not mean, because there is no acceleration clause, that the creditor is going to have to ask for payments for the other installments. For example, if there is no payment of installment 2, there is an action, and then it pays, for example, 3 and 4, and it doesn't pay 5, but then you can sue the debtor again for the non-payment of number 5. So this happens also with SUNAT. SUNAT can issue assessments on the same matter for different periods, and each assessment is different. And as SUNAT was saying, and the tribunal was saying, SUNAT has the duty to look at each assessment and to decide on each assessment, and in practice, perhaps different positions may be taken in connection with one assessment vis-a-vis another assessment. The third issue is the failure to waive penalties and interest. Well, that is not a taxation measure under Peruvian law. I understand that the phrase taxation measure is a technical term under the treaty, but not from a Peruvian law perspective. In Peruvian law, there is no definition of taxation measure. There is no provision that contains that definition. What is absolutely clear and undisputed is that penalties and interest are not taxes and are fundamentally different in their nature and purpose. Taxes are the result of the power that the state has to impose levies, and when exercising that power, the state can meet public needs and provide public services. Penalties are sanctions. They are punishments to those that break the law, and they also make it so that people don't commit those infractions in the future. But all of this scholastic definition of tax in the Peruvian system, the Constitutional Tribunal and the Tax Tribunal have clearly said that a penalty is not a tax because a tax can never be a penalty. Interest, of course, have to do with the right that the state has to receive compensation for having failed to obtain opportune payment of the taxes that should have been paid. So, penalties and interest, well, they are not taxes. Article 28 of the Tax Code defines, however, tax debt, but it does so only as a legislative technique. Article 28 of the Code has this idea of tax debt that includes penalties and interest only as a legislative technique. This does not change the nature of these concepts. We have penalties and taxes. Because of legislative technique and because the SUNAT has the authority on royalties and GEM, Peruvian legislation has classed royalties and GM as tax debts, but they are not that. Royalties are original income of the state. The state collects money because natural resources are going to be extracted from the soil, and these are finite, and there is, of course, consideration. There is consideration because the state is giving up a portion of its assets to a third party under a concession to exploit it, and then the state collects this consideration. It is an original income. It is not a derivative income like taxes. Peru agrees that royalties on hemp are not taxes, but because of a legislative technique and because the administration of these concepts and their collection is in the hands of SUNAT, well, they are included in this concept of tax debt. But this does not mean that royalties are taxes and that GEM is a tax. It would be repetitive and inefficient to mention tax, royalties, GEM, penalties, and interest. The tax code mentions tax debt 124 times. Without this concept, they would have had to say 124 times tax, royalties, GEM, penalties, and interest. And it is simply a legislative technique that has been used to, amongst other things, avoid repetition of concepts such as tax, royalties, and interest. So what they did is they grouped these concepts together under this legal fiction of tax debt. To simplify procedures as well, so that different procedures are not regulated separately in connection with taxes or penalties. This is only a legislative technique issue. Although these concepts of penalties and interest are not taxes, they're not tax measures under Peruvian law, evidently, this term, tax debt, is simply a shorthand for various concepts related to SUNAT's authority. Although the concepts of penalties and interest follow similar procedures in terms of their administration, payment, and challenge, they are not considered taxes, let alone taxation measures under Peruvian law. The fourth topic is the fact that the government should have waived penalties and interest charges against Cerro Verde because there was a reasonable doubt. Article 83 of the General Mining Law and Article 22 of its regulation, I think, were clear, absolutely clear. But at the very least, there was a reasonable doubt. My opinion is that Article 83 of the General Mining Law and Article 22 of its regulation were clear. I think that they clearly established, you simply have to read them, that the mining stability agreements covered the whole of the EAUs. However, even so, at the very least, there was reasonable doubt about their correct interpretation. When there is reasonable doubt, the taxpayers have the right to a waiver of penalties and interest. This under G of Article 92 of the Tax Code. If reasonable doubt exists regarding the interpretation of a provision, taxpayers have the right to a waiver of penalties and interest. The purpose of the waiver is to avoid punishing the taxpayer for reasons fully attributable to the government because it issued an ambiguous provision and therefore there's more than one reasonable interpretation of it. Perhaps the one that the taxpayer applies is not the final one, so the taxpayer cannot be imposed taxes or penalties because it acted under a reasonable interpretation of an imprecise provision passed by the government. So when there is an ambiguous provision, the government has the duty and the obligation to clarify it. Specifically, in connection with tax matters, there is a principle of certainty. The taxpayer should never act in a wrong manner because of ambiguity of the provision, because this guarantees or ensures that there are unnecessary challenges. So Article 170 of the tax code is a peremptory norm, and therefore there is the obligation to issue a clarification rule when it determines that, based on veritable facts, there is a rule that is ambiguous. So the government has an obligation to issue a clarifying rule. When 171 uses the term may, it simply does so to say that there are a number of alternatives for the clarification rule to be passed. One alternative is a law, and the other one is a supreme law. When there is a supreme law, the government simply says, okay, this law is ambiguous, and I'm going to pass another regulation to clarify it, or a supreme decree to do so. In other cases, the alternative is the resolution by SUNAT or the tax tribunal. In the case of the tax tribunal, the code is allowing for a clarifying rule, and the tax tribunal can issue a clarifying rule when deciding on a specific case. The tribunal doesn't really issue general decisions. The decisions that the tribunal issues are those that are heard by the tribunal on appeal. And in that case, the tribunal applies and has applied in countless opportunities Articles 127 and 129 of the tax code that allow it to expressly rule on matters, although those matters were not raised by the taxpayers.
Entonces, este podrá simplemente.
So this only refers to the alternatives for that clarifying rule to be issued. The reasonable doubt exists from the moment that the provision is not precise. And if that is the case, the government has to recognize it immediately and issue a clarifying rule. It cannot refuse to issue a clarifying rule, otherwise the provision of Article 170 would just be paying homage to the flag. I mean, as we say it in our country, it wouldn't have the purpose it's supposed to have. So here there are some facts, several, that show that objectively there is reasonable doubt. They show that Article 22 of the regulation and also Article 83 of the general mining law were imprecise, were inaccurate. Finally, I will discuss item number 5. SUNAT applied the stability guarantees to all of Yanacocha's. Recently, I have received some resolutions that the Beways and Rodrigo's law firms received from Milpo, Yanacocha, and Tintaya, and all of them clearly show that SUNAT acted contrary to what they applied to Cerro Verde. In all the cases, stability was applied to all of the EAUs at Milpo, Yanacocha, and Tintaya. And even if there were investments after the feasibility agreement, feasibility study, and that the position that SUNAT applied to Cerro Verde should have been as not stabilized, if the tax administration had acted the same way they did with Cerro Verde, they should have reflected in their resolution on the assessment in each EAU two different results. One showing the stabilized result and a different one for the items that were not stabilized. All of these resolutions show that there was only one result per concession. In the case of Yanacocha, we have 4 concessions, each with a stability contract. We have the very first one, Chaupiloma South, second one, Chaupiloma North, in Chaupiloma 12, and the third one, Carachugo South, and the fourth one, La Quinoa.
Many thanks for your presentation, Mr. Hernandez, and I take the opportunity to ask some few questions just in order to get some concepts under Peruvian tax law a little bit clearer before we start. And I was across.
Yes, I'm so sorry to interrupt, but just before you move to your questions, I want to note that in PO1 and PO4, it requires demonstratives to have citations to references to the sources of the information. And I didn't want to interrupt the presentation, but the vast majority of his slides do not, and no references to his reports either.
We would kindly request the claimant to add another references and resubmit. the
Absolutely,
presentation.
Madam President. I believe it is only conclusion slides that do not contain an exhibit, but we will double check, and if needed, this is fully supported by the record, would be delighted to add additional exhibit numbers to the presentation and recirculate.
I hope this solves the problem.
Yes, thank you.
Okay, thank you. And when we ask questions as a tribunal, and they are certainly without prejudice to our decision whether we have jurisdiction or not on certain aspects. So I have one really important thing to better understand, which concerns the question whether penalties or interest constitute taxation measures. These penalties and interest claim is 662 million. So for us, it's really important to understand the Peruvian law concept on these penalties and interest. And I understand your colleagues, the respondents, experts, Mr. Bravo and Picon, saying in their second report in paragraph 259 and 260 that they say penalties and interest are clearly taxation measures under the Peruvian tax code. They quote their Article 28 of the tax code, which states that components of the tax debt are tax penalties and interest. And I see now on your slide 18 of today that you say, no, there is no definition of taxation measures, and this is more a legislative technique rather than a qualification. Can you please explain again what you mean with this legislative technique rather than qualification of the nature?
Would you please show me the text that you are citing from Raúl Picon on the screen? May I see it?
Their second report, RER 8, and it's their paragraph 259 and 260.
No lo tengo yo acá.
I don't have it here with me.
The parties will show it on screen. And please in Spanish and English language.
can show it if we can get control of the screen. We can show the reports. Paragraphs 259, did you say? To 260?
259 and 260, it's page 137 in the English version of the second report.
I would propose that you please show paragraph 260, which contains the text of Article 28 of the tax code.
We'll show what the president requests.
Just make sure to show both paragraphs. I think there's a problem because the Spanish and the English don't match. So if it's 259 and 260 in the English, then it appears to be 260 and 261 in the Spanish, which is what Mr. Hernandez will look at.
And please look at then the Spanish version 260 and 261, including the footnote. There is reference made to an exhibit RE 328, an MEF press release.
Perdón, el número es 261.
So is it 261?
Es 261.
You said 261.
260 of the Spanish, le están mostrando el artículo 28.
They're showing you Article 28 of the tax code, Mr. Hernandez. Yes, this is Article 28 of the tax code that says that the tax authority shall require payment of the tax debt that consists of the tax, penalties, and interest. And then it establishes that you have the delinquent interest for late payment of the tax, to which Article 33 refers, to delinquent interest applicable to the fines, to which Article 181 refers, and interest for delays and or installment payments as provided for in Article 36. As I mentioned in my presentation, Article 28 of the tax code, because of legislative technique at the end of the day, adopted a legal fiction under which, or under the term or the expression tax debt, they put together elements or components that clearly do not all refer to the tax itself. There is a difference here in this. There is referring to tax, penalty, and interest, and then it puts together under the headline or under the category tax debt. So the goal here is to avoid that in the tax code, every time there is a reference to the three concepts globally, it wouldn't be necessary to discriminate and mention tax, penalties, and interest. I said it that it was over 100 times. So they just say tax debt to make the taxpayer understand, or a third party understand, that that includes tax, penalty, and interest. But clearly, the penalty is not a tax. As I mentioned before, it's not a levy. All of the definitions of levy or tax, I have never found anything that says that it is a penalty. The penalty is a sanction, but the tax is never a sanction. Therefore, the penalty can never be part of the tax. And on the other hand, it is completely clear under the Peruvian system that the interests under the law are of a compensatory nature. That is, the way in which the state compensates itself for not having obtained the tax payment in time. So here you have delinquent interest. So this concept of tax debt, I would say, is a legal fiction, and it is used, among other things, not to mention in procedures, for example, whenever facilities are granted for the payment of a debt, there is no need to refer tax penalties and interest when under this concept as tax debt, that listing can be avoided. And on the other hand, undoubtedly, this also avoids having to have different proceedings. In the case of royalties that are clearly not taxes, because these are derived revenues. We have original revenue and derived revenue as part of, in the derived revenue is what the state obtains by going to the pocket of the individuals, but original revenue come from the wealth of the state, the assets of the state. For example, the state has real estate, they sell those real estates to me, I pay a price, and that is an original revenue. That's why royalties are not taxes, they are not levies. According to the constitutional tax, it is a consideration, and that whenever we're talking about natural resources that are in the hands of a third party, the state will charge a consideration or also an amount for giving those resources for the use of a third party, or there is a right to use the resources, but this has nothing to do with taxes. This is a way in which the state, by allocating the use and the enjoyment of assets that belong to the state, obtains a consideration. So someone could say that the royalties are a tax debt. Is that correct? But if the royalties are not taxes, the royalties are an original revenue obtained by the state by allowing a third party to use natural resources, and since they will be depleted, then they have the right to charge. The fact that the royalty was incorporated under the idea of a tax debt is part of a legal fiction. This has allowed them to simplify, as we read it in some scholarly writings. This has prevented the existence of very dispersed theories. For example, to challenge royalties, this is the process. For example, someone has to issue a rule for that, but then one goes straight to the tax code. This has been a legal fiction that has allowed to simplify the legislation. And also this allows us to avoid mentioning these three concepts separately, that is to say tax penalties and interest, by putting them under the same concept. And I think that a case that clearly reflects this situation is the royalties and the gem situation, because in both cases we're talking about original resources. We're not talking about tax resources that are derived resources. I don't know if I am answering your question, but at any rate, this also leads me to say, how about tax measures? The concept of tax debt, that once again is a legal fiction, is part of the code as to tax measures, there's nothing like that. The tax code in Peru is the one that rules the main concepts to be applied to tax issues for all sorts of levies. When someone would like to introduce a key issue in connection with taxes, they introduce an amendment to the tax code by inserting whatever is relevant. The tax code or any other rule or regulation includes this concept of a tax debt, and we are going to see that Bravo sites 3230 and 3506. These are rules that refer to tax measures, but they have no meaning at all.
Questions by my colleagues?
I have one. ¿Qué tal? Buen día, doctor.
Good morning. In connection with the royalties, you said at paragraph 86 of your first report that for the purposes of the royalty, the extraction process is not relevant. Not the extraction process, rather the contrary. The processing of the ore, but for the royalty, extraction is important. Briefly, because I know that we don't have much time. Could you please explain why, from the point of view of royalties? The Constitutional Court judgment, given a claim, established that the royalty law was not constitutional, was not unconstitutional. So the court said that the royalties taxed the extraction of the minerals. In other words, the exploitation of minerals. Whenever we look at Article 8 of the mining law, exploitation means extraction, among other things.
So the judgment of the Constitutional Court clearly indicates that mining royalties are paid, they are levy on extraction. And therefore, if it's a levy on extraction, then the processing is simply a way to calculate the amount of the royalty. But the royalty is actually a levy on extraction. And so even under the assumption that Sunat were right, and that the only thing stabilized here was the investment project contained in the agreement signed by Cerro Verde, it wouldn't have to pay royalties under this clear clarification by the Constitutional Court and the law on royalties, which says that royalties are paid for extraction of ore, because in the case of Cerro Verde, all of the ore was extracted from the only mining concession they had. The problem here lies in establishing whether the concentrator did or did not enjoy stability. But the concentrator is at the beneficiation plant. It's not a mining concession. One doesn't extract ore from there. Ore is only extracted from the only mining concession, concession 1, 2, and 3, to which reference is made in the Stability Agreement in Annex Number 1, Cerro Verde Stability Agreement, and that's where all the ore comes from. And that is stabilized. So, to round out, the law says that royalty is a levy only on extraction of ore. This is reaffirmed by the Constitutional Court in its judgment. And the question of processing, well, that's simply a way of saying, well, if I have to pay royalties because I'm extracting them from this concession, which is not stabilized, say, in a real-life example, then I have to now calculate the amount of the royalty. And that is what the law spells out. How is it to be calculated? And that is where processing comes in, because It is calculated based on the value of the concentrate or its equivalent, says the law in its original wording. But even if somebody could extract ore and must pay the royalty, supposing it's not stabilized, but they don't process it, well, as the law says, that royalties are paid for extraction. Nonetheless, in order to calculate it, it says what is of interest is the processing, because it's going to be determined on the basis of the value of the concentrate or its equivalent. Now, anticipating that somebody who extracts must pay royalties, but they don't process it well, the regulation covers that possibility by saying, or the value declared by the seller. It's not been processed, but one must bear in mind the value that you declare for the sale of that ore that you have extracted and upon which a royalty is levied, but it's not been processed. So processing specifically is simply the way of calculating the amount of the royalty. I think that's fine. That's very clear. Well, I would just like to add one small point to say that as of 2011, the law changed, and to determine the amount of the royalty, one no longer had to look at the value of the concentrate, but rather it was based on operating profit.
And understand, let me ask on a different topic, and this is this waiver of penalties and interest if there is reasonable doubt about the meaning of the relevant rule. You already testified on that. And let me just put a hypothetical to you. Should the tribunal, and that is really a hypothetical, but should the tribunal come to the conclusion that the stability agreement and the rules were clear, establishing a clear obligation and to pay royalties for the concentrator, is there nevertheless room for this reasonable doubt in our rule on penalties and interest under Peruvian law, in your view?
Well, according to my view, the law and the regulation were crystal clear. If we could put them up on the screen.
I fully understand that this is your position, but now I would like your answer on my hypothetical. I really want to understand.
Well, in the hypothetical that you put forward, the tax tribunal, what I say, would have held in the negative. But I'm sorry, could you clarify the question, ma'am?
My hypothetical that I put to you is, if the tribunal came to the conclusion that the concentrator did not enjoy stability, and clearly did not enjoy stability, but royalties were to be paid, is there nevertheless still room for this reasonable doubt rule under Article 170 and 92 of the tax code that penalties and interest should be waived?
The waiver of penalties and interest takes as its assumption or its starting point that there's an imprecise rule. So first we have to determine whether or not there actually is an imprecise rule, because if there is an imprecise or vague rule, if there's a rule that allows for more than one reasonable interpretation, then it's not clear. And the government, in one way or another, has accepted that Article 82 in its original version, which was in force when Cerro Verde signed the stability agreement, and Article 22 of the regulation, which was in force in its original version when Cerro Verde signed the agreement, the government has admitted in 2014 it modified Article 82 and it introduced Article 83. And in 2019, it amended Article 22 of the regulation. And if you look at the statement of motives for both of these changes, you will be able to see that the government has recognized that the provision was not clear. And if it recognizes that the provision, the rule, was not clear, it's because it accepts that it's vague. Because what is not clear is vague. So, this is quite simply one of the facts that I didn't want to read because of lack of time from what I read you in my presentation. I said here there are a series of facts that show that, objectively speaking, it was a vague rule, and a vague rule automatically triggers reasonable doubt. And in that presentation, I said here there are up to 7 different types of facts that I'm not going to explain that objectively show the existence of reasonable doubt. And among those is precisely the change in the rule in the mining law, which in 2014 was adopted by the government through Law 3230, and in 2022 when it amended Article 22 of the regulation through a Supreme Decree, I think it's 021 of 2019, or this was not 2022, but Article 22, change made in 2019, the terms clearly lead one to where they mean that the government is recognizing that the rules were not clear. If the rule's not clear, then it's vague. And if it's vague, then I think that in the hypothetical case that you put to me, Madam President, the tax tribunal should waive penalties and interest because there was reasonable doubt. And because the rule was, it had to adopt the clarifying provision declaring that there was indeed reasonable doubt, and as the tribunal resolved the appeal or the challenge.
Then I have only one additional question. This relates to paragraph 19 of your witness statement, where it's about the division of accounts. So it's about the question whether there was a duty to maintain separate accounts for the leaching facility and the concentrator. And you state there, SUNAT itself could have divided SMCV's accounting as it already possessed all of SMCV's accounting information. And can you just explain to us where in Peruvian tax law SUNAT is authorized to divide a company's accounting and which criteria apply for that? And now the experts for Peru say Article 63 of the tax code contain only very limited and specific sets of circumstances in which SUNAT can act this way. And can you explain to us why you think SUNAT would have ex officio, so to say, had to separate the accountings and do not charge the unstabilized regime to the leaching facility?
Madam President, can we make sure that he has the paragraph in front of him? Párrafo 19, su primera declaración, Dr. Hernández.
It is 17, 18, 19, Office Expert Report 8, number 8.
Correct. Desde el párrafo 17.
Well, of the second report, correct. That's what we have on the screen. We can put a different paragraph if you'd like.
Okay. Yeah, okay. 19. Sí. El 19, ¿no es cierto?
19, right? Paragraph 19. I'm going to read it, please.
Yes, please.
Very well. First of all, this paragraph 19 covers the situation in which, in effect, Cerro Verde would have had to show separate accounts in its accounting and separate its accounting. What I have argued is that there was no reason for it to separate its accounting. It did not need to show separate accounts because Article 22 of the regulation clearly states that the obligation to maintain separate accounts is only triggered when one has more than one concession or economic administrative unit, which is not the case of Cerro Verde. Cerro Verde had a single economic administrative unit, and that clearly stems from Annex 1 to its stability agreement. So, in my opinion, as an expert, it did not have to maintain separate accounts because the entire concession was stabilized. Now, when in Article 19 I refer to separate accounts, this is where I'm saying, well, if the SUNAT position were valid, that not the entire unit was stabilized, but only the project, well, and that understanding, then it would not have been able to act to comply with what the rule supposedly said. Cerro Verde would not have been able to do so because there would not be methods for doing so. Please bear in mind, distinguished members of the tribunal, that this aspect must necessarily be expressly regulated in the law because depending on the method or methods that the law requires be applied, one will obtain a different result. One is going to reflect different profits, and therefore the taxation will be different. If I apply because I want to, but the law doesn't prescribe it, if I apply a method X, then I might come up with my tax obligation being 100. But if I apply method Y, I might find that my tax is 40 and not 100. So, had the rule been applied to Cerro Verde that said that it needed to maintain separate accounts, which when it comes down to it means separate accounting, one for the stabilized part and the other for the non-stabilized part, had that been the case, then the question is, where are the rules that would have enabled me, Cerro Verde, to determine with certainty, absolutely sure that the administration is not going to object? Where are the methods that are regulated? Article 22 of the regulation, in its original version, which is the one that was stabilized by Cerro Verde, well, the only method that it establishes is the method of sales. But that is a method that establishes, based on sales, and based on the hypothesis that Cerro Verde would have had to have maintained separate accounts. And the sales-based method would not have sufficed. It would not have sufficed, and this is the important point, even if Cerro Verde were under an obligation to maintain separate accounts and separate accounting. Article 22.3 of the regulation would have had to be applied. One must apply the sales-based method. This clearly would have been insufficient. That one method would have been insufficient to determine profit that would be not subject to any objection at all by the administration, because how can I, for example, well, if I have X number of trucks, say, some are serving the leaching plant, which was what was stabilized, the only part stabilized according to SUNAT, and they're also hauling to the concentrator. Well, the law would have had to have said, in those cases, you'll have to have a system, well, let's say, whereby each day, how much time was the truck working for the leaching plant and how much time was it working for the concentrator. It's crystal clear that the single reference in Article 22.3 of the regulation to the sales-based method would not have been of any use for a taxpayer to be able to determine with absolute certainty and free of any objection what its net earnings would have been. The administration would always be able to say, why did you apply this for the trucks and you're giving me different statement of earnings? And as it's elemental to have a method to be able to determine net earnings, a profit, and the tax, if we're talking, say, of income tax, would have had to have been expressly regulated. And that is why Mr. Bravo and Picon, in their report, well, what they say is, for example, recognizing that the provision did not say exactly how I had to establish my earnings, if I had to maintain separate accounts, Mr. Bravo and Picon say, well, you could have used, for example, the transfer price method. And then the question is, what does the transfer price method have to do with this issue? The transfer price method is useful for determining the market value of goods or assets, and that is used when there are related parties. So what does the transfer price method have to do with this situation? Nothing at all. Plus, the question of transfer prices wasn't current when Cerro Verde signed its stability agreement. But not only that, Bravo and Picon recognized that the provision was incomplete and that it should have been complete and sufficient. They recognize this so much so that they say that one could have applied the method of assignment of goods and services that the law establishes in cases of business collaboration. But here we're not talking about assignment of yields of goods and services, nor is there any business collaboration contract. It's not that I can say, well, this is similar and I'm going to apply it. No, it has to be in the law.
Your report and understand your opinion. My question was slightly different, but I'm fine for the moment. So I want to give respondent now the chance to cross-examine.
Thank you, Madam President. We'll get started and circulating binders, and I'll take the time, take advantage of the time to introduce myself. Hello, Mr. Hernandez. My name is Courtney Hikawa. I'm part of the legal team representing Peru, and I'm going to ask you some questions about your reports today.
Go on.
I'm going to ask my questions in English, and I understand you're going to respond in Spanish, correct?
Correct.
Yes, that's right.
TV says you speak English, though, correct?
It's not my first language, and that's why I prefer Spanish.
Great. So, wonderful. You're going to listen to the translation. We need to agree to proceed slowly in a manner with lots of pauses in between my questions and your answers, and that's for the translation and the transcription. So please note that if I don't respond immediately or ask another question after one of your answers, I'm not waiting for you to say more. I'm just waiting for the transcription. And for the most part, as we've said repeatedly, we have very little time, so I would be grateful if you could keep your answers as concise as possible, also so that I don't have to interrupt you, which I don't want to do. Okay. Do we agree?
Yes, fine.
Okay. Mr. Hernandez, you provided a very long and detailed CV as Appendix A of your first report. I just want to go through a few of those points. So it is correct that you graduated with your law degree from Pontificia Universidad Católica del Perú in 1967.
Correct.
That's right.
You've been teaching there as a law professor since 1974, correct?
Correct, that's right.
Also teach in a Master's of Tax Law program.
I taught in a master's program at the Catholic University and at the University of Lima.
Thank you. I'd like to look at paragraph 2 of your first report, just to confirm it, and I'll read this. I'm going to put it on the screen so you can see it. In this paragraph, you say that since 1977, I've held the position of senior professor at the Universidad Católica. So 1977 is a couple years later than 1974. That's when you started teaching tax law. Is that right? And 1974 is when you started in commercial law?
I recall, not with a total accuracy with respect to the dates, that at some point in time I gave a course on securities, and therefore when I speak of tax law, I started in 1977, but I have my certification from the Catholic University that I am a professor, not necessarily of this or that course, since 1974.
Clarify. Okay, so you further say in this paragraph that you taught courses in Masters of Tax Law program, and then you say that several members of Rodrigo Elias Medrano Abogados Estudio Rodrigo, counsel to claimant, and Estudio Navarro, counsel to respondent, are also professors at the same university, but you have no social contact with them. And several members of Estudio Navarro have been your students during the more than 40 years that you have taught law in Peru. Correct?
Correct.
Then at paragraph 11, if you can go down to paragraph 11. Oops. Sorry. You say you are being compensated in this matter at a rate of US $350 per hour. Your compensation is not contingent on the content of your opinion or on the outcome of this matter. You have no relationship with the parties to this arbitration, their legal advisors, or the members of the tribunal, other than my engagement in this matter and the aforementioned relationships. So the aforementioned relationships are the students and the faculty at the university, correct?
Yes, and coinciding, for example, at different congresses, conferences, institutions, strictly professional relationships.
And do you confirm these statements in your report?
Yes, I confirm them, of course.
You didn't mention, however, that you were also professor to Miss Olano, the president of the tax tribunal, right?
I did not mention that. Actually, as I said in my presentation, I've been a professor for 46 years, and quite honestly, I don't remember who all my students have been.
A lot of students, yes. Okay. So you do not yourself have a master's degree. It looks like you completed 4 courses towards a master's degree in civil law in 1988, but you didn't complete the program, correct?
That is not correct. I completed the master's in civil law, but I did not obtain the degree because I had to present a thesis that I never did present.
Understood. But you also do not have a doctorate degree, correct?
Tampoco.
No, and I do not have a doctorate. That is correct.
You are the founding partner of the law office of Luis Hernandez Berenguel, correct?
Yes, I am the founding partner.
Law firm in 2001 became the law firm of Hernandez Isia, correct?
Yes, at some point in time. Right now, I can't tell you the exact dates. At one point in time, it was just a law firm in Peru. You don't need to be incorporated to operate as a law firm. And then it became incorporated.
You are managing partner of that law firm to date, correct?
No.
No, I'm not the managing partner. The firm today has 150 people. We're more than 90 lawyers. It has its own management, its own administration. I'm not manager or administrator of that law firm.
Your CV, just to explain my confusion, your CV says that you are a managing partner from 2001, but understood. Okay, so at this point in your long and...
Lo fui.
I was, but I'm not. It's been many years since that I've not been.
Understood. At this point in your long and, I would say, very prolific career, I assume that you have assistants or law clerks that help you in drafting your reports and your articles, correct?
Are you talking about the drawing up of these reports or other situations, generally speaking?
These reports specifically.
Fine. In these reports, obviously, I had the support of members from the law firm who work in the taxation area who have helped me because of how extensive the issues are that are involved. So, yes. All of them lawyers from my law firm.
So the process, if I understand it, would be your associates or junior associates or law clerks would write the first drafts of your reports and in collaboration with you would go on refining the reports until the final version, which you review and sign. Correct?
Let's say that they have assisted me in the preparation in connection with certain topics, the determination of background information, the review of provisions that have to do with this issue, and then the drafts started to be drawn up, and I have drafted the reports, and they fully express my position.
You did not explain that process in the reports, though, correct?
I didn't think I had to. Nobody told me that I had to explain how I prepared my report or who assisted me.
Confirming that you did not explain that process in reports because you felt not necessary, correct? Because the information is, you take full responsibility and ownership of what's in the reports, correct?
That's exactly right. I assume full responsibility in my reports because the contents of my report are the expression of what I've done in the end.
Understood. Okay, I'd like to turn back to your appendix A, your CV. And this goes through your appearances at conferences and the like, and it goes through 2021, correct? The year 2021.
Mm-hmm.
Okay, I assume the list of your publications then also goes through the year 2021, correct?
Yes, I'm not sure that all of the publications that I have prepared are there, but the idea was to have a CV that was closest to all the work that I've done.
I thought that was strange because it doesn't look like you published anything since 2008 based on your CV. What's there? The last things are in 2008. So I think that is incomplete because, in fact, I found several publications by you later on, which are not included in your CV. So if I have the names in Spanish, I'll just read the names if you can confirm that you did.
Well, probably. The CV may be incomplete, but I don't think that has much relevance. After 2008, I have not many, but some publications.
And I'll say them in Spanish. Determinación
Determination of the tax obligation that was presented and the statute of limitation of the action to demand payment. Yes, I remember that. Delivery of goods to contractors for consumption and tax effects. Yes, that's right.
Of these documents on the record?
They are not. He has not included them in his CV, and I'm just confirming that they're missing from his CV.
Would this be a good time for a break for the court reporters? Or do you want to continue this line of questions and then we have our 10-minute break? We promised the court reporters.
I can break now. I was going to read a few more titles that were missing from his CV, but I can break now.
Yeah.
It's fine.
Sí. Ya.
Good. That's good. I have to be.
Seem to be missing the expert. We're ready to proceed.
Thank you. Hello again, Mr. Hernandez. I'm not going to go through and read any more titles that are missing from your CV since we've already established it's not complete. But there is one more thing that I'd like to ask about that is not on your CV. You were author and director of a legal publication called Informativo Legal Rodrigo y Hernandez Berenguel, correct?
That's right. That's correct.
And that was an annual subscription publication known in the market as Informativo Rodrigo, correct?
That's exactly right. That's correct.
Okay, I understand it was published in 1961 and ran for more than 40 years, right?
Sí.
If memory serves, in 2002, the publication stopped and the company dissolved itself, 2001, 2002.
Your partner in that company was, the company that published the Informativo was Mr. Luis Carlos Rodrigo Masure, correct?
The Informativo was always the property of Mr. Rodrigo, and then in 2001 I bought some stakes in it, and I became a partner in it, and I ceased to be a member until 2002. So I only had it for a year.
Informativo with you. In addition to being co-director of the Informativo with you, Mr. Rodrigo Masure was also the founding partner of Estudio Rodrigo, the claimant's counsel in this case, correct?
That's indeed right.
Rodrigo Masure, sorry. And Mr. Rodrigo Masure is the father of Mr. Luis Carlos Rodrigo Prado, who is claimant's proving counsel in this case, participating in this hearing, correct?
That's exactly right. We are talking about a publication, or a company rather, that I was a partner of 22 years ago.
Rodrigo Masure is also the grandfather of Miss Lucia Rodrigo, who is a foreign lawyer in the international arbitration practice at Debevoise, claimant's counsel in this case, who is also participating in this arbitration, correct?
I repeat, this relationship that I had is 2001, 22 years ago.
Rodrigo Masure and you are both members of the Peruvian Institute of Tax Law and the International Fiscal Association of Peru chapter. Peru chapter, correct?
Yes, and Mr. Bravo, Mr. Picon, who are experts of Peru, they're also members, all tax lawyers register with the Institute.
Mr. Rodrigo in social and... So you've interacted with Mr. Rodrigo in social and academic events organized by those associations, correct?
Well, this relationship was exclusively on the basis of this company. And in my participation as a partner, there was a social gathering where people were invited to indicate that we were coming together in this company.
AFA Peru chapter granted you the distinction of honorary member in 2009, correct?
The Peru chapter recently did that, honorary member, quite recently. 2 weeks ago, I wasn't in the country even, and it's not 2009. It is 2023, very recently, at a meeting that was held, if memory serves, in early April this year, or perhaps in April this year, I should say, not in 2009.
I'm referring to the 25th anniversary of IFA in Peru, which took place in September of 2009. And I know this because I found a video on the internet where Mr. Rodrigo gave a speech about you.
That is a different institution. Initially, you talked about the Peruvian Institute of Tax Law, and that's the one that gave me an honorary title in April. The other one, it's the International Fiscal Association Peruvian Chapter.
Thank you. So, do you remember Mr. Rodrigo referring to you in that speech that he gave as an unforgettable character, and he talked about your frugal eating and drinking habits and your appreciation for feminine beauty, and referring to your first and your second wife? Do you remember that?
Madam President, objection. What is the relevance to the matters in this arbitration?
Mr. Hernandez has declared that he has no relationships with counsel or advisors in his report, and he recently confirmed that, and I'm asking him questions to impeach that statement.
How are any eating or drinking habits relevant to what is being discussed in this arbitration? You have one of the most
It's not
authoritative...
about his eating or drinking habits, it's about his relationship with Mr. Rodrigo Masure, which was clearly very close.
You have one of the most authoritative tax lawyers in Peru in front of you. I think you should ask questions that are relevant to the case and not
This is my cross-examination, and I'm examining statements that he has made here in this arbitration, and I'm testing them and impeaching his credibility based on his statements.
But indeed, and as such more private remarks, we do not need to learn more about.
Understood. I'll move on.
Y por lo demás, no.
Also, I don't drink. Just saying in passing.
So, Mr. Hernandez, I'd like to discuss the process you undertook in writing your reports. In Appendix C of your report, you include the factual background on which you base your legal opinions, correct?
That's exactly right.
You state that claimant's counsel provided you with this set of facts, correct?
That's correct.
So you did not prepare that document?
No.
No. I received it, and I verified everything that was included there. I verified whether what was indicated there was correct.
That document, I believe, is identical to the one attached to reports by Mr. Otto, Mr. Bullard, Ms. Vega. Did you coordinate with Mr. Otto, Mr. Bullard, or Ms. Vega on your reports?
No.
Never. Never. I didn't speak to any of the three in this connection.
You say, though, that you reviewed the exhibit Appendix C that claimant gave you. So did you check or verify that the facts included in that appendix were correct or supported?
Yes, of course I did.
That appendix does not include an assertion that Cerro Verde's stability agreement covered the concentrator project as well as the leaching project, correct?
Are you asking me whether those events were not there? Is that what you're asking? Well, yes, but I saw other documents. Obviously, the agreement, the approval of the profits reinvestment regime and other documents that were not necessarily there, but I tried to include everything that was relevant.
Actually, we'll get to that point. You made an assumption on which you based your analysis of Senator Verde's royalty assessments. So at paragraph 51 of your first report, you state that to evaluate these assessments, I have assumed that the mining law established that stability guarantees apply to the entire production unit in which the mining concession holder carries out the investment plan described in the feasibility study required to enter into a mining stability agreement. Do you see that?
Voy a ver.
I'm going to look at it.
Por
Your reports are printed out. If you can't look at the screen. Yes, I can look at the screen. I can see the screen.
Sí,
Yes,
correcto.
that's correct.
So you do not provide an analysis on the scope of stability agreements in your report. Rather, you state this as an assumption based on what you include here in this paragraph. Correct?
Yes, let's see. I indicate that I have analyzed those assessments, and I have, of course, examined the relevant regulations and the mining law and the regulations. I'm not an expert in mining law.
The citation here to this sentence cites to Articles 83 and 86 of the mining law. So I understand from your testimony then that you reviewed Articles 83 and 86, and this is what you understood from them. And you did not review the other articles?
That's right.
84, 85 of the mining law? Yeah. Articles 82, 84, or 85 of the mining law?
In general, I saw all of the relevant articles of Title IX of the mining law and the regulations.
Cite them here. So you considered that they were not relevant for your analysis? Is that correct?
I do not cite them here because I didn't feel that they were to be considered in connection with the central matters that I had to look at, whether the concentrator was stabilized or not.
Your admission, yes. The next sentence there at paragraph 51, you qualify your assumption by saying that you are not a mining lawyer, and that you were honorary external advisor to the Ministry of Economy and Finance in 1993 when the ministry was preparing the mining regulations, correct?
Correct.
That's correct.
So I understand when you say that you are not a mining lawyer, that means you're not an expert in the mining law and regulations, is that right?
As a tax law expert, of course, I know the relevant portion that refers to tax matters, but I'm not an expert in mining law.
And you say honorary external advisor. Does honorary mean that that was on a pro bono basis?
Exactamente.
That's exactly right. I received no remuneration whatsoever. It was pro bono. So from 81 onwards, I was a consultant for the Ministry of Economy and Finance, and I never received any kind of remuneration.
In 1993, and that was when the ministry was preparing the regulations. Does that mean that you were specifically advisor on the preparation of those regulations?
Exactamente. Fue una comisión.
Well, this was a committee that was not appointed by a resolution. A number of individuals were included. My former partner that included here, Mr. Feijó, who has passed away, And I was called a number of times to provide information in connection with tax matters related to the Title IX of the law that were going to be included in the regulations and in the Supreme Decree.
Despite that experience at MEF, you do not cite to the mining law regulations in this sentence in paragraph 51 to support your assumption. Correct?
That was the regulations, right? The Supreme Decree, well, Article 22, is part of that set of regulations. It is part of those regulations. But I did not author it. I did not write it. Again, I was consulted in connection with certain tax provisions of that set of regulations that finally was the approved set of regulations.
For your assumption in paragraph 51, though, you do not cite to the regulations. So I understand that to mean that your assumption is not based on an interpretation of the regulations. Correct?
Obviously, when I offer my opinion, I am interpreting the provisions. So I don't know specifically what your question is. Sorry, I don't think I understand.
You did not provide the regulations as a citation to support this statement, so I understand that to mean that your assumption in this paragraph is not based on your analysis or understanding of the regulations themselves. But I believe you've answered my question, so we can move on. So you state from that moment in 1993, when you were external advisor, you formed this assumption regarding the scope of stability agreements, and you've held that assumption since 1993, correct?
Yo lo que digo.
What I state is that I participated as an advisor in the preparation of these provisions, but I also said that in particular I did not receive any request for an opinion in connection with Article 22 of the regulations.
So 1993 was before Cerro Verde conducted its feasibility study for the leaching project and before it entered into a stabilization agreement for that project. And you do not cite here in paragraph 51, where you state your assumption, you do not cite Cerro Verde's stabilization agreement, correct?
At 51, no, I do not cite it, no.
Your assumption is not based on a review of the stabilization agreement, correct?
To draft my report, as I said before, obviously I had to review the stability agreement, and obviously I had to review Article 22 and also the provisions. So my opinions are not based on the lack of knowledge of one or the document or the other or the regulations that you mentioned. Quite the contrary, the fact that I didn't cite them is just because I didn't think it was relevant to cite them, but I did review the agreement, the law, the regulations, and everything relevant to the case.
You reviewed all of those things and you did an analysis, but none of that is described here in your report, correct?
Paragraph, just to be clear, not his entire report.
This is the paragraph in which he states his assumption on which he bases his review of the royalty agreements, and there is no other analysis on his assumption.
There's an annex of the documents, legal documents that he relied on. So it is misleading to base those questions on one paragraph and not the entire report.
I'm referring him specifically to where he states what his assumption was based on.
But I think we heard the expert testifying that he has reviewed the stability agreement and the mining law and regulations. I think this is what is now the testimony.
The stability agreement, although you didn't cite it here in your analysis to come to that assumption, did you review the Supreme Court decisions in order to come to this assumption? or to reinforce or challenge the assumption that you made in 1993?
Sí,
Yes, of course. I reviewed the decision by the Supreme Court of Justice as to 2006-2007 royalty case. That was the only one issued on the subject matter of royalties for Cerro Verde.
You're aware that the Supreme Court in the 2000 royalty case interpreted the mining law and regulations and found that they were limited to the scope of an investment project, and specifically the Cerro Verde leaching project, correct?
I should,
Correct?
pero
but that requires an explanation because the decision by the Supreme Court of Justice, the chamber that decided this, has 5 vocales. 2 of those vocales said that the point of view of Cerro Verde had not been analyzed.
I'm speaking about the 2008 royalty cases. There was no dissent.
I apologize then. I was talking about 2006, 2007.
estamos hablando de regalías.
We're talking about royalties, and the positions are contradicting.
A cassation ruling, like that of the Supreme Court, has the purpose of providing the correct application and interpretation of the law and the unification of domestic jurisprudence. Correct?
That is the theory. I can show you several examples. I can show you, unfortunately, I haven't brought them, but for example, the Supreme Court recently, the same chamber, in 2 case files that were exactly the same, in which a taxpayer is requesting the reimbursement of a tax paid on losses as a result of the liquidation of derivative financial statements. There was a request based on excerpts of fiscal year 2004.
Simply, you're aware of that, correct?
But it does not agree with Peruvian situation in what I am trying to clarify. There are different decisions by the same chamber of the Supreme Court, and this is not infrequent.
That the Supreme Court in the 2008 royalty case interpreted the mining law and regulations and found it limited to investment projects. And despite the fact that you're not an expert in mining law, and that court's opinion, this did not affect the assumption that you came to in 1993. Correct?
Exactly. And the same one that I reached in my report.
And that assumption also was unaffected, I take it, by your review of the facts of the case? For example, Mr. Isasi's report. You reviewed Mr. Isasi's report?
Sí.
Yes. I can tell you that Dr. Isasi has a report of April 2005, if I recall correctly, that says exactly the contrary. And I can also mention that when Dr. Isasi presented before the Congress Commission, I think it was on May 3rd, May 4th, 2006, even though he changed his position and he said that the companies that have stability contracts only stabilize investment projects, he also says something very important in the subject matter of royalties, because he confirms that in the case of royalties, there is a need only to tax minerals extracted from the relevant concession. Therefore, basically, what he's saying in 2006, a year after, when he has changed his criterion and said that the principle, rather that stability only covers the investment project, he ends up saying that royalties are not taxed for Cerro Verde because all of the mineral has been extracted from the concession that has been stabilized.
Yes. Okay. So you've referred to Mr. Isasi's report, not on the subject about which I was asking you, but since you've referred to it, we'll show you a paragraph from his report. And my question would be that...
Is that in the binder? Can you direct them to the document, please?
It's not in the binder, I believe. Is it in the binder? We're showing it on the screen. You can see it.
Could you identify the exhibit for the record?
Yes. It's 494. CE 494. And we'll highlight the relevant part on the screen for you.
¿Puedo ver el documento, por favor?
May I please see the document? Because I only see here a conclusion, but that doesn't allow me to see the context.
Printed out copy of this for now, but you've already made clear that you're familiar with Mr. Asasi's report. So I just want to understand, you saw this conclusion and that didn't affect your opinion.
Madam
This
President,
conclusion on the
he
screen,
asked.
and it didn't affect your opinion.
He asked for the document, and under the rules we've established, if he asks for the document and is going to be cross-examined on specific language, I believe it's fair for him to be able to look at the document.
Certainly, we can print out a copy for him. But since we don't have much time, I will move on. We'll give you a copy of the document for you to review. Okay, so just to make sure I understand, summarize your testimony. You made an assumption in which your report you only explain as deriving from your analysis of Articles 83 and 86 of the mining law, yet you reviewed everything and nothing that contradicted that opinion affected the assumption that you made in 1993. Correct?
Exacto.
Indeed, that is correct.
Okay, I'd like to return to paragraph 51 of your first report. And there, in the last sentence of that paragraph, you say, additionally, I have worked for more than 30 years on tax matters involving mining companies. And in my experience, mining companies typically kept a single set of accounts for each of their production units, since each unit was governed by the same legal regime. Some mining companies, such as SMCV, have only one unit, but other mining companies, such as Southern Peru Copper Corporation Peru Branch, have several. Here you say typically, correct? Typically kept a single set of accounts. Typically kept in English, the English translation is typically.
No encuentro la expresión por lo.
I do not find the expression typically here. You are telling me that here it says typically or generally.
In Spanish
okay.
it says normalmente.
Sí, sí, es correcto.
Yes, that is correct. That's what I said.
Not mean always kept, correct?
That is, based on my experience, this is what I have been able to verify, and we see it with Tincaya.
Please just answer my question briefly, if possible.
Mm-hmm.
Okay, so you give an example of Southern as a company that kept a single set of accounts for their production units, correct?
Solo lo menciono exacto para el caso de.
I only mentioned that in the case of one company that had more than one concession or more than one economic administrative unit.
Okay, so you are speaking here in this sentence as from your experience as a legal advisor to mining companies, correct? So you were a legal advisor to Southern, is that right?
No. I was not an advisor. I was never Southern's advisor. But I knew that was the situation, that this is, I am just mentioning it here in this paragraph basically to mention that contrary to Cerro Verde, there are some other companies that have more than one economic administrative unit. I just knew that Southern had more than one economic administrative unit. I could have mentioned Milpo, Yanacocha, Tincaya,
No soy
but I am not a lawyer.
So your example of Southern in this paragraph is to show that companies have multiple production units, correct?
Yes, that there are companies that have more than one unit in addition to Cerro Verde.
A single set of accounts for each of its mining units? Is your assertion here that Southern kept a single set of accounts for each of its mining units?
No, that's not what I said. I am going to read the paragraph. Also, I have been working.
Okay, so are you saying
pero
then
lo
that
que
Southern...
dice-
Yes, but what it. Yes.
Yes. Sorry, please wait for my
No,
question,
lo
Mr.
que
Hernandez.
simplemente digo,
What I am saying and what I would like to repeat and reiterate that is that in my experience, mining companies only had one accounting for each of their production units, since each unit had to be ruled by this. Some mining companies have only one, such as Southern, but others have more. So I do not share the opinion that you just said.
Is your assertion here that Southern kept separate accounts or a single set of accounts for each of its mining units? Yes or no?
My conclusion here, my reference here is just to say that if Southern has more than one concession, clearly they should have a set of accounts for each unit.
Exhibit RE 355. This is a letter from Southern Peru to MINEM explaining its position on the scope of its stabilization agreement. It's tab 15 in your binder.
sí, acá está.
Yes, I got it.
Okay. So if we can put on the screen the paragraph and highlight the paragraph where it says, for this reason, the contractual guarantees, and I'll read the paragraph. It says, for this reason, the contractual guarantees will benefit Southern Peru exclusively for the construction project of the leaching Electra 1 plants, 2, the additional production that will be obtained from the operation of the aforementioned plants, and 3, the income it obtains from the exportation and sale of said additional production of SXEW cathodes. Do you see that?
Sí, sí lo veo, sí.
Yes, I do see that.
Next, it's clear that Southern's understanding is that its stabilization agreements apply to its project of the construction of the leaching Electra 1 plants.
As I stated already, I am not Southern's lawyer, and indeed, I am reading what you are mentioning. At the end of the day, I do not know what this paragraph is referring to. I think that this is a conclusion given a request presented before the minister. I do not have any evidence, so I do not know what to tell you about this.
Southern also had concentrator projects under beneficiation concessions that were separate from the beneficiation concession for their leaching plants.
The expert has already confirmed that he's not aware of the factual circumstances of Southern Peru copper. So if you want to ask him questions, please direct him to specific documents and specific exhibits in the record supporting what you're saying.
I will. I am directing him to the document that supports what I'm saying. Let's take a closer look at the paragraph. In consequence, and I'll read it. It says, in consequence and in application of the provisions included in the second paragraph of Article 22 of the Supreme Decree number 2493 EM, Southern Peru, to determine the results of the operation of the leaching Electra 1 plants, will keep separate accounting and will reflect in separate results the operations of the sales of the other products resulting from its mining activity. Do you see that?
Yes, indeed. That's what Southern says by means of his president. But once again, I am not aware of the result of this request or this letter.
No.
Would it surprise you to know that that Southern paid royalties on its concentrator plants?
Me sor
I would be surprised because I know that we are talking that in connection with just one mining concession, Southern had an investment project that was stabilized, and Southern interpreted that the stabilization did not cover all of the mining unit, because what I have seen, and this is what I said in the paragraph that you mentioned before, that I have not known of cases of companies that have stability contracts that by having just one concession, they would establish the separation.
I just want to, one last question, because the president had asked you about separating accounts, and you had referred to Article 22. And I would like, you didn't mention at all Article 25, and I'd like to just look at Article 25 briefly.
Mm-hmm.
We'll put it on the screen. Is it in a tab? It's tab 6 of your binder if you'd like to look.
Ah, okay.
I'll read the English. What page is it on? 27. The English, what page is it? I'll read the English for the record. Starting with, the mining activity title holder must submit in cases of expansion of facilities or new investments that contractually enjoy the guarantee of legal stability. Said title holder must make available to the tax administration the annexes that demonstrate the application of the tax regime granted to the aforementioned expansions or new investments. So does that, and my question is very small, short, concrete. Does that change your analysis or your response to the president's question?
Here it is referring to demonstrative exhibits, and I would like to mention that when the tax administration is requesting this, it's not referring to separate accounts, rather separate accounting. In current oversight, SUNAT may tell a taxpayer, please introduce your demonstrative attachments, and it is not that they have separate or different accounting systems. This is something that I prepare as an accountant at a specific point in time if I am requested some information.
No further questions at this time.
Thank you. Ms. Sinistera, questions and redirect?
President. No further questions, Madam President. Thank you.
Thank you. The tribunal has no further questions either, so you are released with thanks as expert in these proceedings.
Muchas gracias, señora.
I thank you, Madam President, members of the tribunal. Goodbye.
So we continue now with the respondents, experts.
Yes, we'll try to make the transition as quick as possible.
welcome Mr. Bravo and Mr. Picon. You have already followed the questioning of Mr. Hernandez, so I think we do not repeat much now. It's just about on you to make your declarations. If you could in turn please read out the declaration for us.
Good afternoon, Madam President. I'm going to read the expert declaration. Could you identify yourselves first? Yes, I am Jorge Bravo. I'm a professor of tax law, and I appear before this tribunal as an expert in tax law on behalf of the Peruvian state. So I will read out the expert declaration. I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief. Good morning. My name is Jorge Picon, and I solemnly declare upon my honor and conscience that my statement will be in accordance with my sincere belief.
Do you have your expert reports RER 3 and 8 in front of you?
Yes, we do.
Has advised you of the process of examination, and so that the cross-examination questions will be directed primarily to one expert. So please go ahead with your presentation.
Thank you. Thank you very much.
Of course.
Disculpen, aprovecho la interrupción.
I'm the stenographer. Let me take this opportunity to let you know, if you're going to switch who's speaking, since I can't see you, since I'm seated behind you, if you could just let me know when that happens so I can take it down properly. Of course.
Are we ready? Good. Please go ahead.
Thank you very much, Madam President, distinguished arbitrators, members of the tribunal, all lawyers present. Good afternoon to all. As I've indicated, my name is Jorge Bravo Cucci. I'm a professor of tax law. I'm accompanied by Jorge Picon, who is also a professor of tax law, and both of us are going to make a very succinct presentation of the main conclusions that we've reached in our two reports which have been submitted to this tribunal. The topics we're going to cover are basically what you see here in the table of contents, and given time considerations, I'm not going to read through it right now. I'm going to go straight into the presentation of the first topic, and I yield to Jorge Picon. The first topic we're going to discuss is to determine whether the stability agreement did or did not cover the primary sulfides plant. To understand stability agreements, it's important to understand the context in which this legislation was adopted. This topic has been addressed by several experts. In the 1990s, Peru had a major crisis, and in order to attract investors, it adopted a number of measures. The tax stability agreements were one of these, but it's important to bear in mind that not only is there mining stabilization agreement, there are three types of stabilization agreements: legal stabilization, mining stabilization, and hydrocarbon stabilization. This will be important at a certain point in time because the reading of the mining law in that context, well, we'll see that there are several mentions in the mining law of the company that receives the investment. Nonetheless, the logic is quite simple. As state, I'm going to give you guarantees. That means I'm going to waive my capacity to change the tax regime in exchange for you making a commitment to a certain investment. That investment should always be contained in the agreements that granted the benefits, whether it was mining, legal, or hydrocarbons. The sequence of the legal provisions adopted in the 1990s, as has been discussed, the Constitution gave constitutional rank to what are called contratos ley. As the name indicates, these are contracts in which the state undertakes to something which often goes beyond what the law could change afterwards. So the single unified text and the regulations have a sequence. They say the mining title holder has to have a minimal level of investment, has to present a stability agreement to me, and then I'm going to grant the stability in a stability agreement. And it's important to mention that the first clause of the Cerro Verde agreement is incredibly specific. It says expressly that the agreement guarantees the benefits specifically for the Cerro Verde leaching project. As other experts have indicated, it is mentioned more than 8 times in the contract, these specific words. And that is corroborated by Article 82, which says that in order to promote the investment, the mining title holders shall enjoy stability, which is granted by the state through the agreement signed. Now, it's important to clearly understand that when the law speaks, it speaks of investment. It doesn't talk about mining unit. It doesn't talk about economic administrative unit. It doesn't talk about concession. And we understand, as a matter of logic, that the mining project is the investment project that is contained in the feasibility study, because that's what the agreement says. Any other interpretation would expand the effect of said agreement. Now, specifically, Article 83 is determinant to figure out the scope of the agreement. Article 83 says the mining activity title holders, well, the effect of the contractual benefit shall apply exclusively to the activities of the mining company in whose favor the investment is made. So it was asked a moment ago, why does the law make mention such as this? And the thing is, when you see provisions adopted in tandem, the legal stability agreement could guarantee the company that makes investment or the investor behind the investor. So 2 types of agreement were signed for each investment. In this case, in the case of mining, stability was only given to the company that received the investment, not the investor as such, as happened in legal, as was the case of the legal stability agreement. And Article 82, which regulates this, is extremely clear. The contractual guarantees shall benefit the mining title holder exclusively for the investment that it makes in the concessions. When one interprets tax issues, one interprets it in a very literal and exact manner. Had the legislator wanted to say the contrary, they would have said the mining title holder for the activities on the concession. And then one would have clearly understood this applies to the concession or to the unit. But in this case, it's quite the contrary. It's for the investment, and the investment has to be made in some place. Now, I'm not going to give one a concession, or rather a stability agreement, if someone buys a building for $10 million. No, the investment has to be made in some place, specifically in the concession or in the economic administrative unit. Basic conditions. In our understanding, the stability agreement applies only to the leaching project. It cannot be extended to any other investment made by Cerro Verde, independent of said investment being carried out in the concession or the economic administrative unit or the mining unit. Now, Mr. Bravo will take it at this point. Thank you. On the second point, we're going to analyze and develop our conclusion as to why we argue that SMCV was required to pay mining royalties with respect to the activities that it carried out at the primary sulfides plant. And the first thing, and this is very important to bear in mind and to develop and to explain, is that mining royalties are not a tax. We agree on this point with the claimant's expert. Here, one must explain the relationship of taxes to mining royalties. In both cases, one speaks of state revenue. Therefore, we are talking about public finance. State revenues, and this has also been said by claimant's expert, may be original revenues when they're obtained from the wealth of the state, in this case, natural resources and exploitation thereof by a third party. And on the other hand, we have the revenues, the derivative revenues, which are those that the state collects from the wealth of private persons. So we understand here that these are not taxes, but rather original revenues. The Constitutional Court, more than a decade ago, resolved a discussion about whether royalties are or are not a tax, and what they said is that this is consideration for the usufruct that the mining concession holder obtains from the resources which are state-owned and that are extracted from mining concessions. Mining royalties have their own rules. They are similar in many ways to, or related to, the rules for taxes, but they are not taxes. So first of all, Law 28258, which is mining royalty law, the law that creates them, and this was modified in a fundamental way in 2014, but it continues to be the same law. Supreme Decree 147/2004, the mining royalty law regulations, and another third provision, which is very important, Law 28969. This law has a series of procedural articles, operational articles, that make it possible to audit or oversee this state resource. Article 3 specifically of this law builds a bridge to the tax code. And this also has a point of connection with what has been indicated by a claimant's expert, the concept of tax debt. This Article 3 specifically states what the provisions of the tax code are that apply to royalties. And it notes, and this must also be indicated, that royalties are fall within the concept of tax debt. Is this a legal fiction? Well, I take issue with what has been indicated by the claimant's expert. It's not a legal fiction. It's a regulation that is specifically stated in the mining legislation. Very briefly, the definition of mining royalty is set out in Article 2, but it's important to bear in mind what Article 3 indicates. During the time of the assessments by SUNAT of Cerro Verde, 2003 to 2011, this was the text that was in force, and basically what it said was that royalties shall be paid on the value of the concentrate. So, if what we're talking about is a use of a natural resource, it is true that the act that gives rise to the royalty is extraction. But it's not just extraction, but also the usufruct that the concession holder makes of that ore. And that usufruct, that value, that earning or profit is going to be generated at the moment of sale. That is why, tying into what Article 3 says, the value of the concentrate, the interpretation up until 2004 was that it was necessary for what to be sold not to be specifically the unprocessed ore, but rather the mineral concentrate or its equivalent, which is what the royalty law states. Now, to conclude, Mr. Picon already explained, our opinion is that Cerro Verde had stability only in respect of the leaching plant, not the investment made in the primary sulfides plant. I'm not going to go on with the arguments in this regard. I think you've already heard them, and therefore the investment project for the primary sulfides plant, which was never included in the contractual guarantee, in our view, did not have the was not covered by the stabilization regime, and therefore mining royalties were applicable to the sales of the processed ore, which obviously had was the value of the concentrate. And I will now yield back to Mr. Picon to take up the next point. In the expert report, it's indicated, imagine I have to pay the royalty, at least that one would not charge interest, and he raises three. We have three arguments in the response. I will develop two of them, and Mr. Bravo the third one. The first argument is that, look, Article 33 of the tax code says that you have to apply to me inflation if the tax tribunal takes time or is delayed in providing its decision. Now, what the expert fails to analyze is that the law 28969, which regulates which provisions of the tax code are applicable to royalties, expressly indicates that Article 33 does not apply. That mention has no legal basis, and to the contrary, Article 7.3 of the royalties regulation expressly states you are going to apply moratorium interest from the time that one doesn't pay it. There's no basis of this article, and it runs against what is contained in the regulation on royalties. The second argument, he says, well, imagine that one has to pay royalties. Don't apply interest to me because the Constitutional Court has already stated in some judgments that, if you could speak a little more slowly, please, of course. The second argument is that there are judgments of the Constitutional Court that indicate that one should suspend the application of interest in tax cases. It's the background that's been cited, applicable. Are the judgments of the Constitutional Court for violation of the reasonable term applicable to royalty cases? No. First, because they're issued only with respect to taxes, and as we clarified a moment ago, royalties are not a tax. Second, they're not general judgments. They are judgments for particular situations, and according to the Constitutional Court itself, they require an analysis of the criteria that are set forth in the overhead, the complexity of the case, procedural conduct of the company, conduct of the public administration, and consequences of the delay. Only when one analyzes that on a case-by-case basis can one reach the conclusion of waiving interest in the particular case. It's important to note that among the documents submitted by the claimant are some videos from a YouTube channel that I handle that I run with Mr. Bravo, where we touch on interest, and I would just clarify that these videos are made for the general public and in colloquial language and bear no relationship whatsoever to our expert reports, which address the specific case of Cerro Verde and not generic public statements that have been made for non-specialists in any event. And Mr. Bravo will handle the next topic. Thank you very much, Jorge. On this next point, we're going to address a conclusion that I think is crucial for this proceeding, which is the claimant's allegation that the exemption of penalties and interests under paragraph Article 170 of the tax code wasn't applied. Reference is made to this in relation to reasonable doubt. I put that here because the text of Article 170 that I'm going to refer to is important. It's relevant. The claimant and its expert have indicated that there would be an obligation by the state to apply or to waive, rather, on its own initiative, penalties and interest at the request of one who alleges that there is a vague provision or an ambiguous provision. We need to note that Article 171 sets forth a power of the state, and it's relevant because we're talking about interest and penalties that have accrued, that have arisen, and that therefore are part of the expectation in respect of collection of revenue on the part of the state. We're talking about revenues for the public fisc, and we're talking about a general principle, which is the waiver of interest for the state. Once there is revenue that the state is not collecting, then there needs to be a very good justification for this. It's been indicated throughout this process that the basis for applying this Article 171 is the ambiguity of a provision. And There's a big mistake there, and I'd like to indicate it. In the article, and you have the first paragraph highlighted in yellow, it speaks more of a misinterpretation. Now, this is important because a misinterpretation is not necessarily going to flow from an ambiguous provision. Here we're all lawyers except the interpreters, and the lawyers know perfectly well that we in our day-to-day work life face ambiguous provisions because the language with which the provisions are drafted is human language. And there may be evident ambiguity. Nonetheless, we don't always get confused when it comes to interpretation. Now, behind this mechanism or this power of the state, there's not just a vague or ambiguous provision. There might be provisions that are excessively convoluted. I'm not going to get into more examples, but basically what one requires is a misinterpretation. That means that one who alleges, one who seeks to have interest waived, is based on an assumption that their interpretation was mistaken. It wasn't the correct one. If we analyze Article 170, what is actually required for the state to implement this power and not charge interest and penalties? Well, there needs to be a misinterpretation, first of all. Second, there must have been failure to pay by the taxpayer. 3, what is required is that the state decide whether to apply the exemption of the waiver, and that to do so through a clarifying provision. A clarifying provision, which could be a law. Obviously, we're talking about state revenue, so it would have to be a law of the Congress or a provision of similar rank, which we would call a legislative decree in Peruvian law, a supreme decree from the Ministry of Economy and Finance, a SUNAT resolution. It would have to be that, or at any rate, an observation by the tax tribunal of similar rank. We reiterate this is a question of availability of public revenues, and therefore there need to be very well-founded reasons for the state to apply this mechanism of waiver and not simply the interest of a private company. Now, analyzing for some of the arguments that are put forward when it comes to the sua sponte application of Article 170, while the lawyers for claimants such as its expert in tax law argue that this is indeed an obligation. They say that it is a right, and therefore, if one exercises that right, and this is in the tax code, and we don't fail to recognize that, automatically the state should waive the corresponding interest and penalties. And for this, they rely on 2 articles, 127 and 129, which I'm going to try to explain in very summary form. What Article 127 indicates is that the bodies that resolve an administrative dispute have the power, once again, it's not an obligation, it's the power to review the facts and the law. So it's not a pure legal review, but it's also a review of the facts. That is the sufficient legal basis for saying that the state, SUNAT, or the tax tribunal, should sua sponte have applied the mechanism set out in Article 170? No, it is not. And then Article 129, which they cite, well, it says that administrative rulings must address all the questions raised by the parties as claims in the case. And they cannot, an administrative body cannot rule on issues that have not been put before it. In the specific case of mining royalties, analyzing the claims and appeals on royalties, we note the following, that the claims and appeals from 2006 to 2009, well, Cerro Verde has argued the waiver of interest before the tax tribunal. What the tax tribunal responded was that it is not appropriate at that point to rule on an issue that has not been raised from the outset. Now, in the 2010-2011 challenges, Cerro Verde did raise a request that such interest be waived. And what both Sunat and the tax tribunal responded was that for them there is no reasonable doubt. Their arguments are set out in the respective resolutions, and therefore they do comply with Article 129. In conclusion, there is no obligation to exempt one who seeks waiver of interest or penalties because of the doubt one may have in the interpretation. There's not necessarily an obligation of the state to do so. And to conclude, I will give the floor back to my colleague. Let me ask for clarification, please. Of course. Now, was Cerro Verde under an obligation to maintain separate accounts for its stabilized and non-stabilized investments in this case? Our understanding is that the answer is yes. One of the big arguments raised by the claimant's expert was that the state should have given Cerro Verde the rules for being able to exercise such separate accounting. But this makes no sense because all mining companies, construction companies, education companies, we work with all these types of companies, and end up keeping records of their costs based on accounting rules. Financial accounting has its own rules. The income tax provision at Article 22 in the regulation says that you should pay your taxes based on general accounting principles. And if I, the tax tribunal, see otherwise, then will so indicate. But otherwise, in principle, one should apply accounting standards. So in this case, the determinative articles for determining the obligation, well, it would be Article 22 of the regulation, which expressly indicates that if you make new investments, or Article 25 rather, that have different tax implications, well, Article 25 speaks of investments, not concessions, not economic administrative units. It doesn't talk about mining units. It talks about new investments, expansions of investments. And it says you have to have controls so that you can be audited by the SUNAT. That's obvious because the tax administration in any country faces more than 1 million taxpayers. And the premise is that everyone needs to respect the rules in force at that time. Now, if you tell me that they don't apply to you to maintain these controls for determining obligations based on the tax regime that you're saying explains to you, that it pertains to you. And that's what should happen here, since there could not be in a review of a tax situation. Well, they carried out, they abided by these controls. It's important to point out that when citing the background, the claimant, and Mr. Hernandez mentioned this a moment ago, he spoke of 3 companies. Well, if you review these rulings, you see that the tax administration never had a different criterion, and we can easily determine this, but we don't really have enough time, and so we'll leave that to any questions you have on the subject matter. And Mr. Bravo will take up the next point. Very well. Mindful of the time, which we understand is quickly running out, I'm going to get into our conclusions with regard to taxes and royalties. We note that all the assessments made by SUNAT of the activities carried out at the primary sulfides plant, which was not stabilized, were correct. That is basically it, and I'd like to conclude my presentation on the analysis made in this proceeding of the supposed or alleged non-existence of an obligation to payment until such time as the administrative stage for tax matters culminates. It's been said here and repeatedly that the debtor only has an obligation once the proceeding before the tax tribunal concludes, obviously against its interests. And actually that's not correct, and I'm going to explain it. The graph that you have up on the screen summarizes very briefly the where a tax obligation arises and how it is that it becomes effective and enforceable. The first thing we need to realize is that for there to be a tax obligation, there needs to be a generating event. The generating event in respect of both royalties and tax obligations is the law. The law sets what is levied, subject to levies, and what is not. And once the generating event occurs, the tax obligation arises. The taxpayer has an obligation, or the administration has the obligation to determine the tax or royalties, as the case may be. If the taxpayer doesn't make the determination, it's the tax administration that must do so, or that may do so. The determining act by the tax authority, which it does after an audit, which is to provide guarantees. Well, if it determines that there's a debt, if it determines that there's an obligation that wasn't paid, then it indicates that the obligation exists. And not only that, not only does it determine the existence of something that has been omitted, but rather it quantifies the obligation, and which makes it enforceable on the taxpayer. And not only that, but from that moment, it begins to generate the effects particular to administrative act. That efficacy that the Determination Act has in the Peruvian case is suspended for 20 days, which is the time frame indicated in the tax code for the taxpayer to be able to make use of their right to defense, to decide whether or not to bring a claim or a challenge. Now, if the taxpayer who's been notified with such has been so notified, decides not to challenge the act of assessment, then it gives rise to a obligation that may be enforced coercively. Now, let us look at the possibility of the taxpayer challenging the Determination Act at both levels. So first, does the obligation exist? Yes, it exists. Is there an obligation in which the debtor has the legal duty to follow through on the obligation? And on the side of the creditor, what exists? A right to demand the payment. That right, which is called enforceability or demandability in Peruvian law, is suspended. That right is suspended, but what that does not mean is that there is no obligation, nor that there is no legal obligation to make the payment. What does this mean? Well, if during the challenge and appeal stage, the debtor of the royalty or taxes opts not to pay, it's not that they don't have an obligation not to pay, but rather they are deciding to fail to comply, and that failure to comply creates damage for the state, which is compensated for by interest on arrears or moratorium interest. The expert for the claimant, and we fully agree on this point, has indicated that the legal nature of moratorium interest or arrears interest is to pay compensation. Why? Because there's a default. And what is that default? It is the failure to pay the tax obligation in the time frame indicated. Were it true that there's no payment obligation until it is subject to coercive enforcement, then how could default interest in respect of that event arise? So here what we're indicating is that one must draw a distinction between the obligation and the enforceability, which is different. I know that I'm running short on time, and basically what I want to indicate is that from our standpoint as tax experts, we're not damages experts, and we don't claim to be so, is that we think that if there is some harm, that which can be gauged through the default interest, which may compensates for harm, has arisen from the moment of determination. And as tax law experts, and Mr. Hernandez knows this perfectly well as well, a company doesn't recognize harm in its financial statements only when they are coercively forced to pay. All attorneys, even those of us who are not tax law experts and who represent clients in proceedings, know perfectly well that there are contingencies, there are degrees of contingency, and those should be reflected and this is indicated in Article 37. I'm talking about international accounting standards. If it's remote, likely, or possible, if there is a probability of greater than 50% that the case will not turn out favorably, however good we consider arguments to be, there is an obligation to recognize a contingent liability in the company's books and to not wait for there to be coercive collection. And with that, I conclude. I beg your indulgence, Madam President, if I've gone on so long. This is now tax measures. It's been said with respect to tax measures that there's no such concept in Peruvian law. There isn't.
But that does not mean that we couldn't interpret what a tax measure is. Well, I disagree with that. I disagree with the other party's expert. A measure is an action, is a decision by the government. Decisions by the government on tax matters, well, how are they shown? Regularly, via regulations, procedures, rules. These are acts of power. The government decides on tax matters, whether it's going to create taxes, apply interests, waive interests, apply penalties, etc. Why is it that we need to reduce the concept of tax to the tax itself that resists no analysis? Default interest or penalties are tributes. I've never said that. That's not acceptable. So, of course, this is a compensation that is part of the regulatory tax rules, right? Yes, of course, and the tax code is one of them. The tax code does not create any kind of tax. Is the tax code not a tax rule? We have to think about this. The breach, and I'm not an expert in damages, but I would think that when the state shows that there was a harm, well, and we consider that the concentrator was not guaranteed, that would mean that there was hypothetically a breach. Thank you for your attention.
Thank you very much to the two of you. We would like to proceed as we did with the claimant's expert and ask some initial questions, and then the parties will enter into their set of questions. And I start, and you will not be surprised by my questions. They are very similar to the ones I had for Mr. Hernandez. So my first question relates to the question whether the penalties and interest constitute taxation measures, and just to better understand, if one takes the position, and this is undisputed, you just confirmed it, that royalties are not taxes, one could arguably think, okay, penalties and interest, which are also a civil law, whatever, and a concept, are separate and like an annex only to this non-tax. So there can be no taxation measures if one imposes penalties and interest. And I understand you saying, oh no, they are nevertheless taxation measures. Do I understand correctly that you base this on Article 3 of the mining royalty law? Because you say, now on your last slide, this is the term tax measures refers to decisions of the state that may hand it down through its legal or regulatory provisions, and Article 3 of the royalty law exactly constitutes such a legal provision.
Yes, Madam President, indeed. What we said is that one must not confuse a tax with taxation measures. It's something that needs to be clear first and foremost. Royalties, in principle, are not taxes. That's true, they're not taxes. Does that mean that there are no tax regulations that govern certain aspects of royalties? No, because they exist, and you made mention of them. Article 3 of that law indicates expressly what the tax rules of the tax code are that are applicable to the royalties, and that transforms the royalties in taxes. Of course not, but there are certain tax rules that apply to royalties, and that is the explanation. Let me see if I understand you correctly. You say that there are tax rules, and you're saying that royalties are not taxes. Those tax provisions turn penalties and interest into taxes? No, we're not saying that at all. Okay, so they're not taxes either. No, they're not.
Taxation measures, right?
Así es. Repetir la...
Please repeat your question. Repeat your question. I think that there was an issue with the translation.
My apologies. Now I think you said they are not taxes, the penalties and interest, but nevertheless they qualify as taxation measures. Is my understanding correct?
Yes, you understood that correctly. That is what I was saying. Although they're not taxes, taxes may not exist by themselves. They need, for example, a penalty regime. They need also other kinds of rules so that the tax may be complied with, and formalities may comply with. And they have that nature as taxation norms. I don't think that this is clear. We have to clarify this. What you are saying is that they need a penalty imposing regime and regulatory norms, but this does not change the nature of the penalty. They're not taxes. Some tax regulations may be applied in the periphery as to how something is calculated, but the nature is not changed. They're not taxes. No, they're not taxes because fundamentally they are trying to bring compensation for a breach, but we're not saying that they are tributes. Okay, the royalties are not royalties are not tribute and penalties are not tribute, right? Yes, in the case of income tax, it is not. So that is not the discussion. It is clear to us that there are provisions that regulate the periphery, quote unquote. So the periphery of the tax phenomenon, with the existence of the income tax and value-added tax, then a tax regime wouldn't really be possible.
Second question relates to Article 170. You explained that in your view, Article 170 of the tax code does not only require an existence of an ambiguous rule, but much more, so you do not consider it applicable in this case. But let us also ask, and to the hypothetical that we already posed to Mr. Hernandez. So just going on the purely hypothetical assumption that the tribunal would get to the conclusion that the concentrator was not stabilized, and so a payment of royalties were due. On this purely hypothetical assumption, would a waiver of penalties and interest be even an option under the Peruvian tax code, or would such misinterpretations or reasonable doubts become obsolete by this decision?
So the first assumption would be there. That is to say, that a conclusion was reached and that the interpretation that the company had was erroneous. It was an erroneous interpretation. That is the first element. The second element would be Did the taxpayer pay the debt? If it did so, then the government cannot really get what has been paid already or condone it. If these are debts that were not paid because of whatever circumstance, then we would have a third level of analysis, the decision of the Peruvian state. The state would assess the situation, and it would have to decide whether there is room for failing to collect money from this company in the form of penalties and interest. So there has to be some kind of merits to the decision by the state. So we cannot have the benefit only to a company. We would need a heterogeneous group of people that misunderstood the regulation. We're talking about disposing of the funds of the state. When a state authority decides via a resolution or a law not to collect something that had accrued in favor of the state, then it's going to have to justify to the state oversight agencies why is it that a collection was not made. So you have to have good justification for your actions, and I think that claimant's expert understands this the same way as we understand it. These are very specific situations. It's not like the taxpayers are able to get this effect at all times. Sometimes the decision is automatic. There is no need to ask for anything else.
Con respecto a este artículo.
In connection with Article 170, what you are saying is that penalties and interest do not proceed here. Is this the only case? Only if these requirements are met, then the penalties and interest are not going to be applied? Has there been no other case in Peru in connection with the application of interest and penalties if it doesn't meet these assumptions? There are some cases in which the case law has indicated that there's a waiver of these interests when there is an act of God or force majeure. This is not the case. It's just an example, a pandemic situation. So these are not the only cases. These are the ones regulated by Article 170. Yes, that's right. But there could be other cases. Yes, cases of act of God or force majeure, for example. Yes, for example.
Now let me come to the last set of questions, which concerns this double accounting. On slide, let me see what slide this is, 24 of your presentation, you said there are precedents in Peru of mining companies that keep independent accounts for the different tax regimes they apply to investment projects. And here you refer to the example of Tintaya. We earlier heard today that there seems to have been also an example for southern Peru. So please explain in more detail what are these examples that you refer to.
Of course. The idea of oversight helps us determine the tax regime to be applied. Stability agreements create an atypical situation. Taxpayers are governed by a single law, but there are certain taxpayers that have signed stability agreements and they have a number of tax regimes that they need to apply. For example, they have different income tax rates and other tax rates for other taxes. So the law says you have to separate the accounting out, because how I, as SUNAT, will know what to apply to each stability agreement. Article 25 of the regulations of the mining law, Title 9, specifically indicates that when new investments are made that are subject to a tax regime that is different, the taxpayer must have the right accounting. To explain to Sunat, why is it that it is paying taxes differently in connection with one project versus another project? Mr. Hernandez said that it is not keeping up counts. But for those controls to take place, they have to be accounting controls in nature. So in the case of Southern, what we have is in a single administrative unit, you can have two projects with different tax regimes applied to them. If that's the case, the company is going to have separate accounts. And he asks himself, how can this be done? Well, cost accounting is very simple, and the experts on the matter have indicated this. Cost accounting identifies indirect costs, direct costs, and shared costs. That's basically what you do to separate things out. So identifying direct cost and indirect costs in each project will need additional oversight. Is it possible to separate these things out? Yes. Were they obligated to do that? Well, if there were two different tax regimes applied to them, yes, of course, they were obligated to do it. And the tax administration is always going to start from the premise that the general rule applies, and the taxpayer is the one who's going to have to say, okay, no, this is governed by Agreement A, this by Agreement B, and this is the manner in which things are determined. In none of the cases that we cited has there been regulation, because we're talking about accounting rules. If SUNET disagrees with the application of the accounting rule, that's going to be the matter of a different dispute. But the possibility of separating out accounts, well, that is governed by accounting rules, general accounting rules.
But claimant made the argument that SUNET should have divided somehow then between leaching and concentrator. And so is it then on SUNET to apply some sort of a split to the best of its estimate? Or is there no legal basis for this, and this does not happen in practice?
Both in practice and in the regulation of the agreements, if a company has a number of tax regimes, and in this case, the agreements allow for this, the company is obligated to show why is it that it's not applying the general regime. So SUNET is going to say, how have you calculated project A, B, or C? And SUNET is going to say, I'm going to review this. And of course, the tax authorities are not going to do the accounting for the company. They are only going to put forth a request. And this happens every day in the tax fields. We, in 95% of what we do has to do with cases against the tax authority. And they say, okay, well, show this expense, show all the receipts for this expense. Oh, you can't show it? Okay, then you can't ask for it. So what happens is that the taxpayer must show the tax authorities the reasons why it's doing A or B. If it doesn't do so, the tax authority, Peru or any other country is going to say, okay, look, I asked you the question. You either didn't really provide support for this, or the support you provided did not convince me. And that is why I am applying this tax to you.
Thank you. This concludes my question. Dr. Cremades, do you have follow-up questions?
I simply would like to ask a question in connection with this concept of reasonable doubt, ambiguous provisions. You also talk about Franciscan rules. I'd never heard that expression before. Franciscan rules, you said. That's something that I never heard before. In this specific case, Articles 82 and 83 of the law and 22 of the regulations allow for claimant to have a reasonable doubt, or Is it simply that there was a breach and then you said, okay, well, I'm going to try to defend myself if something comes against me? Was there a reasonable doubt or not in this case? I think that the law was interpreted in the wrong manner. So 170.1 talks about a wrongful interpretation, an erroneous interpretation. In lawyer parlance, I spoke about Franciscan rules, so a very brief rule is what I meant. In the specific case that we're talking about, tax lawyers talk about, quote-unquote, reasonable doubt, because we're saying that the interpretation of the provision was erroneous. On the basis of these explanations, I think that the interpretation by Cerro Verde was erroneous. And that is why they try to say that the state has to waive interest and also penalties. And I would like to supplement the answer. In the private activity we do, we look at different operations, financial institutions, and right now we have a case pending for hundreds of millions of dollars, and the tax authority think that there should be a waiver, but SUNAT does not want to provide a waiver, and SUNAT is asking for information. And we have told the company, okay, you can believe whatever you want to believe, but you need to support everything, because a tax law is very clear. The law says if you do not provide the evidence when I required it, then you cannot do it. You have to pay first, and the taxpayers know that that's the rule. We are convinced that we should really pay no taxes. In this case, it is clear that the tax administration thinks the opposite. So should I not submit anything and go to the tribunal? No, of course not. So we tell our clients, submit all the supporting documentation, and everything can be then analyzed by the tribunal to be able to put up a good fight. Because if I do not submit documents during the audit, later on I cannot submit them. And the tax code has very strict rules. And all of the tax code of Latin America have, and in other countries as well, have rules like that. Okay, I'm sure that, the Franciscan order wouldn't want to be included in this discussion. How would you respond to the arguments in connection with the 2014 and 2019 reforms? If things were so clear, why was there a reform? When you're talking about the reforms, are you talking about the reforms in connection with royalties under the Obala administration? Yes, I'm talking about the mining law, Article 83B, and then Article 22 of the regulations. Okay, so you're talking about the amendment of the single unified text and the regulations. Okay, what we have indicated in the report is that these are rules that broaden the scope of the tax regime. It's not that these regulations, specify something or provide restrictions. I think Jorge wants to say something. That's his issue. Working in the tax group, I have worked for over 6 years in connection with the preparation of tax rules for income tax, value-added tax, etc. So the fact that, I have a rule in 98 or 99, does that change things before? No, I have to interpret the rules at that time. So why do I do that? Well, because I don't want any more problems, because I know that there are a couple of taxpayers that think the opposite, and I would like to avoid problems in the future. Well, but if things are so clear, why the change? What we are discussing here is whether things were clear. You're saying, okay, if you didn't want problems, the problems existed because things were not clear. If things were clear, you didn't really need any kind of change. We're not saying if this is correct or incorrect. We're talking about if this was clear or not. One of the provisions that was cited by the claimant has to do with when is it that the SONAT reports are binding. And it was said 2012. It was said 2012. Well, there are rules in the 1990s and that said that there was a hierarchy. There are more than 100 reports that were signed by me as well, but the hierarchy was mandatory.
Disculpe.
The fact that in 2012 the binding nature of SONAT's report was incorporated. Did that mean that they were binding? No, they were binding since 1990. No, we're talking about something else, sir. The same applies to taxes. Oftentimes, when you have legislation, you do not think about the 5 taxpayers in the past, but the thousands of taxpayers in the future. So you would want to have a rule that's crystal clear, but that does not mean that there is a reasonable doubt. But if you need crystal clear situations, it means that in the past it wasn't crystal clear. Well, when clarifying a language, there's a difference between crystal clear and the concept of reasonable doubt according to the tax code. We can have doubts in many cases. Again, the tax regulations are specific in nature because they apply to millions of situations. It is impossible for a provision to regulate everything that happens in the economy and every single event that the taxpayer does. But of course, there are effects, right? So you need to adjust that provision. And those adjustments cannot be chalked up to the fact that the other rule was vague. No, you have to think about the future. You have to think about the thousands of cases you're going to have in the future without setting a precedent saying, well, whatever happened in the past was wrong.
No further questions from the tribunal for this moment, so it seems to be a perfect time for a lunch break, and we see us back at 1:30.